We shall now shift gears towards Attorney Raja Bhandari from the law offices of Raja Bhandari in Sex and Settlements. This afternoon, this attorney will define for us the difference between a will and a living trust. That's right, the difference between a will and a living trust. Come on close. Let's see, let's look, and let's learn.
Good afternoon. This is Raja Bhandari from Law Offices Raja Bhandari and Sex and Settlements. Welcome to Qanun. Friends, first of all, I would like to say thank you to all your wishes, all your emails, all your phone calls, and all your questions. We thank you so much because this particular segment is based upon your questions and our answers. We try to accommodate as many as we can, and this is for the awareness only. Of course, for particular specific questions or any other case, you can consult an attorney of your choice. So let's start. I have a few questions I'm going to go over. The question is, what is the difference between a will and a trust? Now, this is a very interesting question. I will be elaborating this in coming weeks. However, let me address these questions first. Now, of course, both are documents, legal documents, and they are your wishes that when you are no more, that the property you have should be distributed according to your wishes. A will is a very simple document. As far as trust is concerned, is a more of a very large document, and it also contains, you can also say that it's estate planning also. So let's see that what are the major differences between the will and a trust. The very first one is the probate, which is a very important issue, friends. You have to remember that if you have a will, you have to probate it. Means your beneficiaries has to take the will to the court where you reside in that county court in the probate section, and they have all 9 yards to do it. It can take from 6 months to 12 months, sometimes it's longer, as long as there is no contest. Now, that is how the will is being treated. As far as trust is concerned, trust bypass that probate section as long as it's funded properly, as long as it's been directed properly, as long as it's been followed whatever is in the trust. So that's the big difference, that you spend a lot of time, lot of money when you have a will. Of course, that is the right way to do it because you open the estate. As far as trust is concerned, you bypass completely, and then it is available to the beneficiary immediately right after the deceased. Now, executor. In the will, there is an executor which we call executor, personal representative, administrator. As far as trust is concerned, in trust there is a grantor. The grantor is the one who set up, and then after that there are beneficiaries. So that is the difference between the will and the trust. There is an executor, there is a grantor. Now, cost. Of course, will is a very simple will, very small document, and it's very less expensive as far as trust is concerned. But you have to remember, once you pay for the trust, you will be avoiding so many expenses in future. And for example, let me give you an example. As far as will is concerned, let's say the will is going to cost you $1. At the same time, trust is going to cost you $5 or $10. But at the same time, you have to understand that as of today, if you hire the attorney to handle the probate, they will charge you easily $5,000 to $7,000 retainer fee. So in that particular money, even less than that, you can prepare a trust. Not only trust, but complete estate planning. That is a very precious gift to your kids, that they don't have to go through probate, they don't have to go through hassles, and they have available the assets right away, right after their parents or whoever write that trust for them. So will is less expensive, trust is expensive, but at the same time you pay less money, less hassle later on in the trust. Now, time. Will can only be executed once a person dies. Means if you write a will, then obviously that is going to be effective when the person is no more. Then you have to take the will and then go to the probate section and then do the following. whatever their procedure is, whatever their time frame is, whatever their final accounting is. So it is a complete 9-yard situation when it comes to the probate. Now, when it comes to the trust, now remember that trust can be for you also. Let's say that if I'm preparing a trust today for my kids, it also available for me, whatever the way, the wishes I have, it starts working right away. For me also, as well as for my kids also. So the will is only for the beneficiaries when you dies, that's what effective. Trust is effective right away the moment you create it. Now we have changes. Will cannot be changed. Let's say that if I prepare a will and if I die, that is going to remain there as far as the will you created. When it comes to the trust, trust is irrevocable and it's irrevocable. If you have a revocable, which is the case most of the time with the people that they prepare the revocable trust, during your lifetime, you have complete control on the trust you created. You can change it, you can amend it, you can rescind it, you can completely dismantle it. So that means you have complete control on the trust. For example, it's a very funny thing that if you have a child and he's not following your footsteps or he's not listening to you in will, of course you can change it during your lifetime, you can revoke the previous will and then make a new one. But at the same time, if you die, that's going to remain there. As far as his trust is concerned, you can change any time beneficiary. You can include, exclude that way. So friends, this is the major differences between will and a trust. Send us your questions. We will be happy to answer more questions on this particular area. This is Raja Bhandari taking a leave for this week. So long.